In 1974, James St. Clair became the first lawyer in history to defend a president in an impeachment investigation on television.
The main issue has to do with Watergate. And in substance, it seemed clear to me, and I argued that there was no evidence the president knew anything about it in advance.
James St. Clair lost that argument when President Nixon was forced to turn over audio tapes that showed him directing and participating in obstruction of justice in the Oval Office. James St. Clair returned to his Boston law firm with the admiration of the entire legal community nationwide. He continued his distinguished career as a trial attorney and lecturer at Harvard Law School. James St. Clair was defending a guilty client, but he did it with respect for the seriousness of the impeachment process, respect for the rules, and respect for the court decisions that forced his client to release the damning evidence against himself that ended the Nixon presidency. Rudy Giuliani is no James St. Clair. Donald Trump's lawyers are the worst lawyers who have ever defended a president of the United States. Their legal arguments are cartoons of legal arguments. Nothing embarrasses them. When their frivolous arguments get crushed by judges, they just make more frivolous arguments. The resolution the House of Representatives will pass this week outlining the impeachment investigation procedures in the various committees will give Donald Trump's lawyers special rights in the Judiciary Committee hearings, including the right to cross-examine witnesses. But those rules also give the chairman of the Judiciary Committee unique power that was never thought necessary in an impeachment proceeding before this one. If the Trump lawyers bring their obstructionist game into the Judiciary Committee hearings, they will pay a price immediately, right there in the room. That's next. The committee shall report to the House of Representatives such resolutions, articles of impeachment, or other recommendations as it deems proper. That sentence appears in the 1974 House resolution authorizing the House Judiciary Committee to conduct an impeachment investigation into Richard Nixon. That same sentence appears virtually word for word 24 years later in the 1998 House resolution authorizing the impeachment investigation of President Bill Clinton. And that sentence appears virtually word for word as the last sentence in the House resolution on impeachment that will be brought to the House floor for a vote on Thursday. The House Judiciary Committee will adopt new rules to comply with that resolution that grant the president and the president's lawyers special rights during the Judiciary Committee hearings on impeachment, including the right to object to questions asked of any witness and the right to question any witness. But the final provision in the new rules of the House Judiciary Committee for impeachment hearings says that if the president blocks witnesses from testifying and refuses to produce documents, quote, the chair shall have the discretion to impose appropriate remedies, including by denying specific requests by the president or his counsel under these procedures to call or question witnesses. Joining us now is Julian Epstein, the former Democratic chief counsel to the House Judiciary Committee he was there during the Clinton impeachment hearings, and E.J. Dionne, an opinion writer for the Washington Post and a visiting professor at Harvard University. And E.J., they didn't need rules like this for James St. Clair. They didn't need rules like this for President Clinton's lawyers because they presumed reasonable behavior in these hearings. But that's not the case with Rudy Giuliani and the Trump lawyers.
No, it's not. And I think that this rule is very clear. The president will be given every right to intervene, but he won't be given that right if he decides that he will deny the committee and, by extension, the public itself, legitimate information. There are some other things they've done in these rules, I think, that are interesting. One is the committees that are being excluded from this process. They include the Oversight Committee and the Foreign Affairs Committee. They're not part of this at all. And guess what? There are a couple of members of the Oversight Committee who are among the Republican flamethrowers. Jim Jordan and Mark Meadows are kept out of the process this way. Lee Zeldin of the Foreign Affairs Committee, another flamethrower, is kept out of the process this way. I think that's another way in which they're trying to keep this from becoming a circus. And lastly, it really appears that they've learned from the Mueller hearing, and that the 5-minute rule, everybody asks a question for 5 minutes and you move on, really doesn't give you great hearings. So that in the Intelligence Committee, and by the way, Adam Schiff is the king of the hill in this process, the way this rule is written, because all of the early hearings go through him. In the Intelligence Committee, there'll be a block of 90 minutes to be divided, 45 minutes each for the chairman and the ranking member, and they can delegate that to a committee staff member. So you can have a consistent line of inquiry and not have it all cut up the way it was so often in the Mueller hearing.
And Julian Epstein, that's the good news about the House Judiciary Committee, too. We're going to be seeing a lot more of Barry Burke, the counsel who asked questions in that committee before, because this rule allows the committee counsel to be asking the questions for 45 minutes at a time. But I want to get your reaction to what control you think this rule gives Chairman Nadler in the House Judiciary Committee.
Well, lots of control, but you expect that on the committee chair. And let me just say, in 1998, we gave the Republicans gave the White House exactly the procedural guarantees that the Democrats are now giving to the Trump White House. It's almost word for word in terms of procedural guarantees. And after those were voted on by voice vote in the committee. Here you actually have a House rule that's in place, which is much stronger than you had in 1998. After those rules were put in place, Tom Mooney, who was the chief counsel of the Judiciary Committee, and myself had to meet with Chuck Ruff, who was the White House counsel, to discuss the implementation of those rules. And during that meeting, while there was intense disagreement during the 1998 impeachment, but during the meeting when we had to negotiate how those rules would be carried through, there was complete cooperation by the White House. The Clinton White House cooperated at every step along the way, even though there was intense disagreement on the overall impeachment. And that's totally contrary today. Republicans have completely painted themselves in a corner by relying on the process argument that Nancy Pelosi has now taken away from them.
Julian Epstein, we're going to need your expertise on this as this process moves on. Thank you for joining us. E.J. Dionne, thank you for joining us. Thanks for checking out our YouTube channel. Subscribe by clicking on the button below for more from The Last Word and the rest of MSNBC.